It's Salamatu today, and today we are going to be talking about negligence under the law of tort. Yes. So before we start the video, if you have not subscribed, kindly subscribe. If you have subscribed but you haven't turned on the notifications button, please turn on the notifications button so that when we post new videos, you know. Like our previous videos, share, comments. So negligence is a breach of the legal duty to take care which results in damage. This actually means that you must have owed whoever it is that brings an action in negligence against you a duty of care. Then you must have breached that duty, and which breach must have resulted in the person suffering some damage, right? So in the case of Relied versus Birmingham Waterworks Company Limited, the court held Baron Alderson that a negligence is said to have occurred when you fail to do what a reasonable and prudent man would have done given the same circumstances, or you do something which a reasonable and prudent man would not have done given the same circumstances. So the test really is what the reasonable person would have done in those same circumstances, which you failed to do, or what the person would not have done, which you did. Negligence is not actionable per se. So remember when we were talking about assault and battery, we mentioned that they were actionable per se, which means that you shouldn't have to prove that you suffered some damages in relation to the battery or assault before you can be successful in your action under the tort of assault or battery. But with negligence, there must be a proof of damage. Remember when I was talking about the test, the 3 tests, I said that there has to be a duty of care. The duty must have been breached, and which duty must have caused you damage. So negligence as an area of law, as an area under the law of tort, is not actionable per se. You must prove damages. So straight we start with how to establish duty of care, because the idea of duty of care is very, very broad, right? So you remember when I was starting, I mentioned the case of Birmingham Waterworks Company Limited. That might give you a little bit of an idea. But let's look at the case of Derry v. Peak. Now in Derry v. Peak, it was held that a duty of care arises when there is such proximity between the parties, so that in the absence of care, or if one person fails to exercise care, the other person is likely to suffer some damages. So the idea in Derry v. Peak is it borders on proximity, and proximity does not necessarily have to be physical. It may be geographical, it may be it may be anything. But then once we can establish that kind of closeness between the parties, irrespective of how intangible that closeness is, it's a duty of care is likely to arise. This idea of proximity seems to have been reinforced or restated in the case of Donoghue versus Stevenson. So in Donoghue versus Stevenson, the plaintiff went to a bar with her friend, and her friend ordered for her some ginger beer. Now, after she took part of the first part, she poured out the first half of the beer, took it, and then when she finally poured the final half of the beer, a decomposed milk came out of the bottle. Now, according to her, she suffered some shock and some gastro problems, and so she was suing the manufacturer, which in this case is the defendant. Now, the defendant, of course, denied liability for a lot of reasons, but then the court took advantage of this case to make a very profound statement on the matter of duty of care and who you owe a duty of care to, which is closely related to our earlier statement, or the earlier statement by Baron Alderson in Derry v. Peak. Now, this statement was made by Lord Atkin in Donoghue v. Stevenson. He said that you owe a duty of care to your neighbor. But who is your neighbor? Your neighbor is that person who you can reasonably foresee as being affected by your act, okay? So that you have them in contemplation anytime you avert your mind to that act. Now, once this is established that this person is your neighbor by virtue of whatever Lord Atkin has said, it is important that you take all reasonable steps to ensure that your neighbor is not injured or ends up not being injured by your act. The emphasis is on taking all reasonable steps. So if you meet the requirements of reasonability and then still your neighbor ends up being injured by your act, then you may not necessarily end up being liable. So the test is, as we've mentioned, what would a reasonable person do or not do in relation to that particular person. But then that person we are talking about must be your neighbor, and neighbor within the meaning of Lord Atkin's statement in Do Not Give Mysterious, as somebody who is likely to be injured by your act. So if you're a doctor who is likely to be injured by your act, a patient, if you're a lawyer, your client, if you are, so that kind of relationship kind of exists. So that's generally the test for determining who you owe a duty of care to. Okay, but then let's also look at the case of Dorset Yard v. Home Officers, where Lord Reed was of the view that the idea of neighborhood or neighborliness in Do Not Give versus Stevenson is a bit broad. It opens the floodgate so that almost everybody or anyone can fit into the neighbor principle. So he said, he made a statement in that case that the neighbor principle will work fine in most instances, but in almost all circumstances it has to be modified, or it has to be treated in relation to the circumstances of every case, in relation to the facts of every case. So not every case will come to court that looks exactly like Do Not Give versus Stevenson, so that neighbor principle in Do Not Give versus Stevenson applies like verbatim or in total. But depending on the case, Lord Reed in Dorset Yard v. Home Officers is saying that it has to be modified so that the facts are taken into consideration when we are applying Do Not Give versus Stevenson. So this is the general idea about neighborliness and who you owe a duty of care to, right? This is where we end today's video, and we've mentioned what negligence is. We've spoken about the fact that as a matter of requirement, there has to be some damage suffered before we can say that before an action in negligence can be successful. We've also mentioned that who you owe a duty of care to is largely going to be determined by whether or not the person is your neighbor in law, and that idea is expressed by Lord Atkin in the case of Do Not Give versus Stevenson. And we mentioned Lord Reed's caution about how we apply the idea of neighborliness in Do Not Give versus Stevenson. Once again, if you have not subscribed to our channel, kindly do so. If you have, but you haven't turned on the notifications button, turn it on, and follow us on Instagram. We are on Instagram as Spoon Store. Like, comment, and share. Thank you.